All right, everyone. Thanks again for joining this morning. We'll dig into our presentation. And I just want to let everyone know that please, we encourage you to use the question and answer box throughout the presentation. It'll be found at the bottom of your screen. Feel free to type any questions in there and we will address them either during the presentation or at the very end.
I want to introduce myself. I'm Sean Fitzpatrick here with Sports Legal Support. This is my colleague to my right, Colin Ritzema. We also have Ian, who you'll hear from in a second here. And the purposes of this presentation is to talk about some of the new rules the state of Michigan implemented on January 1st, 2020. We've actually been educating the legal market here. Ian and I did a presentation up in Saginaw in front of Judge Durans and the practitioners in that region. We also recently did a presentation with Judge Martha Anderson from the Oakland County Bar Association in the Inns of Court right before the whole pandemic. So we thought it was a good opportunity to come and educate the legal community about some of the new rules and some of the tools that we have in our disposal to help you adhere to those rules. A little bit about our company. We are a full-service litigation support company. We have offices in downtown Grand Rapids as well as West Bloomfield. Court reporting and video services. We've been doing a lot of remote depositions lately. So we did a presentation last week for the MDTC on remote depositions. So if you're interested in seeing that, we do have it on YouTube. Obviously, a service that we provide is computer forensics and electronic discovery, as well as trial support services. Like Colin said, we encourage you to ask questions throughout this presentation. Colin will be the moderating the presentation, and we'll get those questions over to us. And I'll kick it over to Ian so he can introduce himself and then dive into the presentation.
Good morning, everyone, and thanks for joining us. I'm Ian Williamson. I have been practicing law for approximately 16 years, primarily in the field of complex commercial litigation and business disputes. I'm a partner with the firm of Mantes Honigman PC. We're headquartered in Troy, Michigan. We also have offices in St. Louis, Missouri, and in Manhattan and New York. Over a 16-year period of practicing law, I've seen a lot of changes in the way we conduct discovery and the things that we are looking for in discovery. And those of you who have been practicing as long or longer than I have probably seen even more dramatic changes over the course of your careers. When I started practicing back in 2004, at that time, when we talked about eDiscovery, we were really just talking about getting emails produced. And even at that time, we were usually just seeing printed out copies of emails. We spent, as many of you probably have as well, spent weeks and weeks in rooms full of boxes of documents, looking at paper copies of documents. And it wasn't until a few years later that I started to see more widespread adoption of things like Relativity as platforms for viewing electronic copies of documents. Native format document discovery has become more important over the last 10 to 15 years as attorneys have begun to appreciate the need to capture document metadata, and we've all started to understand how that metadata can help us in our cases. More recently, over the past 10 years or so, text messages, social media postings have started to play more prominent roles in some of my cases, certainly probably some of yours as well. But the breadth of ESI today is already significant, and it's continuing to increase. This is going to be one of the most prominent discovery issues that we are all going to be facing over the next decade or so. And with the adoption of these new court rules by the state of Michigan at the beginning of this year, we have some more specific targeted language in our court rules now that deals directly with ESI issues. And that's what we're going to focus on today as we go through this presentation. Now, the umbrella of ESI is a large one, and it keeps getting bigger. Electronically stored information really just refers to any type of data that is created, altered, communicated, and stored in digital form. Now, there are a number of different types of ESI that we're going to talk about, and that many of which we're probably already familiar with. Communications, of course, everyone's familiar with emails, email attachments, text messages. We've all probably seen these used in cases and explored through discovery. Some of the newer sources of communications that we're seeing are messaging apps like Slack, Kik, WhatsApp, Snapchat, in addition to enterprise messaging systems like Slack, things along those lines. Documents in native format, another form of ESI that many of you have probably dealt with. These would include word processing documents, Excel spreadsheets, spreadsheets from applications like Apple's Numbers, digital presentations like this PowerPoint presentation we're looking at now, digital photographs, things along those lines. But we're now starting to see newer sources of ESI that are probably less familiar and that are continuing to increase. Some of these would be things like information from the Internet of Things, basically items that are embedded with software, sensors, and electronics that are connected to the Internet. This could be a smart television in your home. This could be a Nest thermostat in a building. All of these things are potential sources of ESI. Now, jumping back to communications for a minute, emails and attachments are familiar to us all, but the thing that we need to be aware of when it comes to emails is that the volume of email communication is continuing to increase at a significant rate. In 2019, for example, the average number of emails sent per day in the United States was 293.6 billion emails. Between 55% and 67% of those emails are estimated to be spam email communications. This, for us, makes all of our jobs more difficult. The average worker with an email account receives 96 emails per day. I know many of you probably receive 100 or more emails per day. I know I do. And the average worker receives around 45,300 emails per year. What this means is that for one email custodian or ESI custodian, just looking at an email account, we've already got a very significant amount of ESI that we are wading through in the discovery process. Text messages. You're familiar with these. SMS text messages are cellular-based messages that are text-only messages that are limited to about 160 characters. The volume of these really exploded between 2005 and 2015. After that, SMS text messages flattened off somewhat because of the wider introduction and use of messaging apps. Text messages are important sources of ESI because they're quicker and less formal than an email. Response time for a text message is considerably faster. And in fact, studies have shown that people respond to text messages up to 6,000% faster than they respond to emails on average. Users tend to be more candid and less guarded in quick text exchanges, and this has been used with devastating results in a number of different high-profile cases. We're all familiar, of course, with the Kilpatrick trial, in which text messages were a very prominent part of the evidence introduced. Today, a lot more businesses are using SMS text messaging to communicate regarding appointments, deliveries, things along those lines. But where we're seeing the real significant growth at this point in electronic communications is through instant messaging apps. These, of course, are similar to SMS messages, but applications like Facebook Messenger or like Apple Messenger have the ability to send much longer messages and to send things like embedded pictures, embedded video files, and other types of files. Now, these were initially limited to computers. Some of you may remember the days of AIM, ICQ, and some of these early messaging apps, but there's been a significant migration to mobile devices over the past decade. That's where we see the Snapchats, the lines, things like that. Like SMS text messages, these also tend to be sources of quicker and more candid communications. So to the extent that messaging apps are being used by parties in our cases. But we really need to be considering these as potential sources of ESI. The same thing is true for enterprise messaging like Slack or like messages sent through Microsoft's Teams. These can be valuable and overlooked sources of information. For attorneys who aren't really familiar with these applications, it may not be something that you think of, but we all need to be more aware of these going forward. Now, I mentioned the Internet of Things earlier. Many of you have probably heard that term. Many of you probably have these devices in your homes. A lot of us have Nest thermostats. A lot of us have things like Amazon Echo or Google Home, smart hubs, things that we use to control different devices in our houses. These are the things that we are really going to see increasing over the next decade. We are surrounded today, often literally, with potential sources of ESI. I said earlier that the umbrella of ESI is getting bigger, and these are some of the key new sources that we as attorneys need to be considering depending on the cases we're working on. And these include things like GPS-enabled devices, like a Fitbit or a smartwatch, smart thermostats, smart smoke and carbon monoxide detectors, doorbell cameras like Ring. There have been a number of cases where people have used data taken from doorbell cameras to prove or defend claims. Virtual assistants I mentioned, like Amazon Echo, Apple Siri, Google Home. Some of these devices tend to record portions of conversations, and this data has been used certainly in criminal trials, and is probably going to become more prevalent for people to be looking for this information in civil cases as well. These devices also include things like smart TVs, some of which contain microphones and cameras, and some of which tend to log data. We don't think about these things this way, but a lot of these devices are really like spies in our own homes and that we wear on our bodies. Depending on the circumstances, the information that these devices catalog can be collected, and we as attorneys can use this information to prove up elements of our claims or to defend against claims. So what kind of things can this data tell us? Well, GPS information can tell us when a person comes and goes from a location. GPS information can tell us the general location of a device in relation to nearby cell towers. If you need to demonstrate where a person was at a given point in time, information from a mobile phone application or from a Fitbit can be useful in that regard. There's the potential for recorded conversations I mentioned, things like Amazon Echo and Google Home. Things like smart home hubs and thermostats and things like that can give us information that reflects when a person may have been more likely to be in a building. If the thermostat is set to increase the temperature or if the lights are set to turn on. Different entertainment devices can provide information that can reflect when these devices are accessed and what type of content is being accessed through them. This is also information that can be used to demonstrate where a person was at a given point in time. Now, all these devices include ESI that's potentially discoverable and should be considered for discovery, but they can also present some significant challenges. There needs to be a determination as to where the data is stored. Does the device have an internal drive? Does the device kick information up to the cloud and store it on a server somewhere? If it is stored on a separate server, where is that server located? It may be in another state. It may even be in another country, which will really complicate sometimes efforts to obtain that information. You've got to consider what's the data format. Can that data be rendered into a format that is easily reviewable and understandable? You've got to consider how difficult and expensive it's going to be to obtain and interpret that data. And you've got to consider how important is this data to your case. This is going to be more important for us all going forward because of the new proportionality rules, which we'll talk about in a little while here. Now, case law shows us that courts are already ordering parties to produce this type of data from these new ESI devices. But before we even ask for it, all of us as attorneys need to consider whether this data is specifically relevant to our claims and defenses and whether it can be obtained and interpreted in a cost-effective manner. Now, the best time to start dealing with ESI questions is really at the very beginning. as soon as you suspect or know that a legal dispute is brewing. Regardless of which side you're on, whether you're on the side of a potential plaintiff, whether you're on the side of a potential defendant, there are a number of things that can be done at the very beginning that will help with ESI management throughout an entire case. Some of these things involve identifying known or likely sources of relevant ESI on both sides. This helps us understand what we need to be preserving on our own side and what we need to be requesting from the other side. We, as attorneys, of course, need to advise our clients to halt any ongoing or scheduled deletion or destruction of ESI. We need to be advising clients to preserve and copy potential sources of relevant ESI so they aren't inadvertently destroyed. We need to be notifying ESI custodians that they need to prepare for preservation and likely production of ESI. This can involve preparing preservation letters to be issued to adverse parties, sending preservation letters to our own clients, having conferences with our own clients and with their employees to talk about these ESI issues. And as this landscape becomes more complex, we all should be considering whether it makes sense to engage experts very early in the process to assist with pre-litigation ESI management. Some things that I know I have considered doing in more recent cases have been things like imaging hard drives or imaging mobile devices even before I know a case is going to be filed. If I suspect that my client is going to be asked for data on these types of devices, if I can image them early, get a snapshot of these devices as they existed at a specific point in time, leave them with a custodian, with an ESI consultant, then that makes it a lot easier for my clients to continue to go about their business without necessarily fearing that their computers and devices are just going to be taken away from them for unknown and potentially extended periods of time. So, Sean, why don't you talk to us for a minute about the eDiscovery timeline from your perspective as an expert who assists clients with these issues?
Sure, Ian. So just to kind of piggyback off of the last slide here, Ian, it's got to come down to how the attorney wants us to handle the collection process. So sometimes our clients are comfortable with the self-collection process, and they have maybe an IT individual at the company that is familiar with the workflow of the databases and the systems of the company, and they're comfortable with having that person do the self-collection. Other times, we're engaged in more complex matters, maybe if it involves 5 or more custodians. We're engaged for theft of trade secret cases, sexual criminal conduct cases, where there's a little bit more sensitivity to some of these matters. And so typically when we're brought in, to Ian's point, we go in and we do a analysis or a collection of these devices, and now our clients can walk away feeling good that the preservation has happened, so there won't be any spoliation issues to deal with down the road. So from that point, we like to take that data and call it down. And what do we mean by calling? Is we like to take the whole universe of data and try to trim it down. And we do that by several methodologies. We do a process called deduping, where we eliminate duplicate emails, for example. We go through a process called denisting, where we eliminate system files that are not relevant to what we're trying to do. And then we have filtering by more logical filtering by keywords, by date range filters. So these are all things that we can kind of do to begin to pare down that massive amounts of data that we just collected. So from there, we go on to process that data, and processing it just really involves taking the documents and putting them into a uniform fashion. And this is the stage where we will process emails, Excel spreadsheets, Word documents, PDFs, and now they're all uniformed and ready to review. From there, we take we look at a review platform. Most probably have heard of Relativity is the Cadillac of our space. That is a hosted review platform that was actually developed by attorneys, and this is where clients can do their review. As we saw, and Ian talked about it, there's just a massive amount of information that we need to go through. So in order to do that, we need a vehicle, and that's where providing a relativity or a like product can help. From there, this is where we're relying on the attorneys to do their analysis. And now they're going through the database, and they are just looking for those documents that they will end up producing and are relevant to the case. After that stage is done, they come back to us, and then we can take that tiny little small subset of data, right? We started here, and then by the time we get to step 6, hopefully we're in a small subset. Then we can convert these to PDFs. We can base label them, and then get them off to opposing counsel.
Thanks, Sean. Let's talk a minute about the new rules that we're going to be discussing today. With the new updates to the Michigan court rules, the updates that specifically deal with ESI that we're going to address today include issues of preservation, initial disclosures, proportionality, and the new availability of an ESI conference between counsel. We're going to look at the updates to the specific rules that address this and talk about some strategies to leverage expert assistance to potentially win ESI arguments that we're all going to be having going forward. Let's start with preservation. So before we jump right into Rule 2.313D, let's talk about this generally. When we become aware that a legal dispute is brewing, most of us are already thinking about discovery. We're asking our clients to provide us with email and text message communications. We're asking people when critical communications took place, what was the format in which they took place, who was there, who knew about it. We're doing our own investigation to determine how we are going to prosecute our claims or defend against those claims. At the same time, most of us are warning our clients they need to make sure that this information is available. They need to make sure that it's preserved. They need to stop any automatic deletions and do things like make copies of email archives. This can be very important. For example, if you've got a client who is on the verge of being terminated from a position with an employer, maybe they're a shareholder that's about to be pushed out, their access to an intranet or their access to company email could be lost at any minute. So preserving that access and getting that data is one of the first things we're talking about. We need to be thinking about ESI as a bigger picture, not only because of these new sources that I discussed earlier, but also because there have been some changes in the rules that might punish us if we fail to do this. Under Rule 2.302B5, a party has the same obligation to preserve ESI as it does for all other types of information. Now, there used to be a provision in that rule stating that courts may not impose sanctions for failing to provide ESI lost as a result of the routine, good faith operation of an electronic information system. That language is no more. That safe harbor no longer exists. So we have the same obligation to preserve ESI that we do to preserve any other type of potentially relevant information. But what if a plaintiff in a case is asking for every scrap of ESI under the sun, including things like old backup data tapes that we can't even access anymore? Does that mean that we, if we're defending cases, have an obligation to provide every bit of this ESI? Not necessarily. Under 2.302B6, a party need not provide discovery of ESI from sources that the party identifies as not reasonably accessible because of undue burden or cost. On a motion to compel discovery or for a protective order, the party from whom discovery is sought must show that the information is not reasonably accessible because of undue burden or cost. So in other words, if we're the party who doesn't want to produce the ESI, the burden is on us to demonstrate that the request isn't reasonable. But recent changes to the rule help to clarify that even this isn't a guarantee of preventing the discovery. If that showing is made, I'm going back to 2.302b6 now, the court may nonetheless order discovery if the requesting party shows good cause, considering proportionality under subrule B1 and the limitations of subrule C. The court may specify conditions for the discovery, including allocation of the expense, and may limit the frequency or extent of discovery of ESI, whether or not the ESI is from a source that is reasonably accessible. So we've got new language there that introduces the concept of proportionality, and we've got new language there that says that specifically that the court can specify conditions that include the allocation of expense. So from the side of the party who is producing the information, if we think it's unreasonable and we can demonstrate that there's an unreasonable and undue burden, even if we're not able to prevent that discovery from being produced, we may at least be able to shift the expense of production over to the other side. And what this tells us is that reliable information about the cost and difficulty of data extraction is going to be critically important to both limiting discovery and shifting costs. So jumping into 2.313D, which we have on the slide here, this is the rule that governs failure to preserve ESI. This rule also used to include language preventing courts from imposing sanctions for lost ESI due to routine operations of electronic information systems. That language is no longer there. New language says that if the ESI that should have been preserved is lost because a party failed to take reasonable steps to preserve it and it can't be replaced, the court can order measures no greater than necessary to cure any prejudice to the other party and order appropriate remedies if a party acted with intent to deprive another party of the information's use in litigation, from an adverse inference all the way up to dismissal. So basically, parties can't blame automated document retention policies for destruction of relevant ESI anymore. If there's an automatic document retention policy in place or a destruction policy, we've got to be aware of it. We've got to tell our clients to put a stop to it. And if we don't do it, we might be punished for it. So what can we do to help attorneys protect clients in light of these rule changes? We can take preservation seriously from the beginning. We can instruct clients early on to institute litigation holds specifically to ESI issues. And we can bring experts in early on to help us identify and preserve the ESI that we know is likely to be relevant in the case or could be relevant in the case. So let's talk for a minute about initial disclosures. This is a new issue in the state's court rules. For practitioners that are often in federal court, you're already going to be used to doing initial disclosures, but in state court, we haven't really been required to do this. The use of initial disclosures was proposed in some of the business courts and some of the business court protocols that when they were initially introduced. But I have to say that my practice is almost exclusively in business courts when I'm in state court, and I don't think I have ever once been required by a business court judge to actually do initial disclosures with my opponent at an early stage in the case. It just really hasn't come up or hasn't really been enforced or widely used. Now, though, the landscape is different. It's in the court rule. We've all got to be doing it just like we do it in federal cases. Under Rule 2.302A1, as part of the required initial disclosures, Rule sub A1D requires that we provide a copy or description by category and location of all documents, ESI, and tangible things that the disclosing party has in its possession, custody, or control, and may use to support its claims or defenses, unless this would be solely for impeachment. So we've got to identify the ESI in our initial disclosures. Rule 2.302A1E also requires that we provide a description by category and location of all documents, ESI, and tangible things that are not in the disclosing party's possession, custody, or control that we know we may use to support claims or defenses. So we've got to identify and disclose the ESI that we have, and the ESI that we know is out there that we don't have, we've got to tell the other side that it exists, and to the extent we can, we've got to tell them who has it. Initial disclosures for plaintiffs under the court rule are due 14 days after the answer is filed. Initial disclosures for defendants are due the later of 28 days after the answer or 14 days after the plaintiff served their disclosures. Now, parties are often just checking the boxes when you're putting initial disclosures together. These often tend to be sparse. They often tend to include a pretty minimal amount of information, but these can be important if it turns out that known sources of ESI haven't been properly disclosed. This is something that can cause parties to lose credibility in front of a judge. It can even lead to sanctions if that ESI turns out to be particularly relevant ESI. So the best practice here, again, conduct a meaningful investigation of the ESI very early in the case, at or before the pleading stage. Sean, why don't you talk to us about how you and your team work with clients to do these initial ESI investigations?
So it is our best practice when we're engaged to do what's called an evidence mapping process. And what I mean by that is that we identify all the custodians that are potentially relevant to the matter. And then we're like a detective. We ask a lot of questions. We get to learn their systems, learn what devices and accounts they had under their control. So this gives our client a snapshot of the universe of all potentially relevant sources of ESI. And we go through this systematical interview process, and you can see here, this is one of our tools that we use, and we identify those custodians. We do timelines. We talk about structured data, which is QuickBooks, maybe a CRM tool. And so we like to package all this information up so the practitioners and the attorneys know, okay, this is what we're dealing with. This is a universe of data, and now from that point, from the attorney's perspective, now you can begin to call down that data, but at least you know what exists out there. And so this will be one of the handouts that we prepare and send out to all the participants today, and clients use this themselves, Ian, to do these interviews, or they engage experts like us to do these.
So having an evidence map like what Sean is talking about here, having a document that reflects an investigation of ESI is something that can be used defensively by us as attorneys to bolster arguments that we have taken reasonable precautions to ensure that ESI is being preserved. So if our clients are being accused of not properly disclosing ESI or improperly deleting ESI, and we can demonstrate that we've undertaken a process like this at the outset to try to identify the ESI that is out there and to try to make sure that we're preserving it, that puts us in a better position to win those arguments about whether our clients have acted improperly. And from the plaintiff's perspective, of course, having these types of conversations with clients at the outset of a case tends to make clients think a little bit harder about what potential types of ESI might exist. And it helps us, when we are prosecuting claims, to get a better picture of what we should be asking for when we're sending out our initial discovery requests. So let's talk for a minute about proportionality, because this is another new addition to our Michigan court rules that attorneys who practice in federal courts are already going to be familiar with. The adoption of proportionality in our rules brings us more in line with the federal rules. Proportionality can serve as a check on Michigan's historically broad discovery landscape. I know that historically we have been on the plaintiff side able to ask for a lot of different types of information, and there's a lot of case law out there saying that discovery is broad and open, and that Michigan supports our ability to basically look into just about anything. But with proportionality now, it is more difficult for parties, I think, to insist on wide-ranging and expansive discovery in cases where there are relatively small amounts at issue. So to the extent that parties have in the past had a little bit of an easier time maybe filing a relatively small claim and using that litigation as a fishing expedition to gather a lot of data, I think that we're going to see that type of litigation activity dwindle as a result of this. So under 2.302B1, parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claims or defenses and proportional to the needs of the case, taking into account all pertinent factors, including whether the burden or expense of the proposed discovery outweighs its likely benefit, the complexity of the case, the importance of the issues at stake in the action, the amount in controversy, and the party's resources and access to relevant information. So these are our new limitations here. The discovery has got to be proportional to the needs of the case, and it tells us specifically some of the things that we need to consider when we're making that proportionality determination. The burden or expense, whether that burden and expense outweighs the likely benefit, how complex the case is, the importance of the issues at stake, the amount of money that's in controversy, and the resources and access to relevant information. Now, there's, to my knowledge, little to no Michigan case law on the proportionality issue yet. This was just introduced at the beginning of this year, and of course, with the pandemic and the shutdown starting in mid-March, there hasn't really been a lot of time for us as litigators to really interact in a meaningful way with the new rules yet. I know I've done initial disclosures in some cases at this point. Many of you probably have done the same, but cases just haven't gotten advanced enough under the new rules for me to have really grappled with the proportionality in the context of my state law cases. I'm used to doing this in federal court, and it's going to be interesting to see how business court judges and other state court judges handle these issues. There are a number of U.S. district court cases in the Sixth Circuit that apply proportionality analyses to various types of ESI. I think these are probably going to be our early sources of authority for the arguments that we're making to state court judges. But proportionality is a fact-specific analysis, and it really changes with every case. A good understanding of the types of ESI at issue, how they can be produced, and what the actual cost is going to be key to winning proportionality battles. If we are on the side of a party who is producing information, and we don't want to produce that information, and we come in armed with real relevant information about how long it's going to take to get that information produced, what the actual cost is going to be, that gives us more credibility in the proportionality battle. At the same time, if we're the party that is requesting information, and we can bring that same type of information to bear, that makes it easier for us to argue against a party on the other side who is just saying generically, Judge, this is thousands of gigabytes of information that's going to be so expensive to get all of this produced. If we have information on actual costs and actual time, and we're requesting the information, that gives us more credibility. A key way to help make this happen, again, get your experts involved early on and get some clear, relevant information about what these costs are likely to be.
So, Ian, I wanted to show here kind of what if we all printed this out? We can all relate to paper and what a box of paper looks like. And frankly, we still get calls from clients asking us to print out emails, gigabytes of emails. So, you know, we can all relate to paper. And so the average size case, as you can see highlighted here, is 5 to 20 custodians is the average size case. So 10 gigabytes of data of emails alone, and we're not talking about any of these other sources, Ian, just the emails can equate to about 250 boxes of paper. So just think about that. If you know how much review you'll have to do even on the average case here now. So we just want to put some context on how much data we're actually dealing with here and why it's important to have a plan in place and to have these review platforms in place. Because as we've seen in our cases, the main cost driver is the volume of data collected. The most expensive process in all this is the attorney review time. And so if we can get you to a place where you're reviewing a smaller subset of documents as opposed to every piece of spam email or every I'm going to lunch email, and that's where we want to get to. And so we do that by these calling methods that we talked about earlier. And so we just want to make sure that we're communicating with our clients these tools and these strategies to really drive the volume down. In terms of talking about a budget, we're typically engaged by our clients to, well, how much would all this cost? And so we have, and this would be one of our handouts as well, we have this total litigation cost model. And this is an Excel spreadsheet, and the numbers can be manipulated based on your assumptions. And so from this point, we can plug in numbers based on the amount of data that we have, and we have some averages that we've computed in here to give our clients somewhat of a budget that they can work against. And this is not just our costs as eDiscovery vendors. This is, take into consideration, a lot of your costs as the attorney. Another way that we facilitate this is we create a custom statement of work where our clients will come to us and say, this is my situation. These are the custodians I want to collect and we'll need to review. And so can you create a budget based upon this information? And so from there, we take that information that we've been given, and we now can create a budget that is pretty close to being accurate most of the time. And now you have something real that you can come to the table with.
Yeah, I think having the availability of these budgets that really show a breakdown of what needs to be done to get a specific type of ESI produced and what the actual anticipated cost of that production is. I think this is a useful tool that we're all probably going to be using a form of this more often going forward. In past discovery disputes that I've been engaged in, I can say much of the time you end up with attorneys on both sides, one side saying, Judge, this isn't going to cost that much, and the other side saying, Judge, this is going to cost hundreds of thousands of dollars, and neither side really is bringing much to the table in the way of any real evidence of what that cost is going to be. So the ability to have something like these budgets, I think, is going to be key to being more effective in these proportionality fights. So there's one more change to the court rules that we want to talk about, which is the introduction of the ESI conference under MCR 2.401J. About 10 years ago, the Federal Judicial Center did a survey of attorneys. And one of the things that they were focused on in that survey was how ESI was being addressed early in cases. As a result of that survey, the Judicial Center found that only 1 in 3 respondents included any discussion of ESI in their 26F conferences. Only 1 in 5 court-ordered discovery plans included any provisions relating to ESI at all. The study also found that 46.5% of plaintiffs' lawyers and 55.5% of defense lawyers reported issues relating to the retention and preservation of ESI that occurred over the course of their cases. And the survey also found that more than 30% of lawyers on any side reported issues with collection, review, and production of ESI. So when that study was done 10 years ago, clearly there was an issue with people not addressing ESI at the beginning of a case and then experiencing issues relating to ESI over the course of litigation. So has the situation improved? Maybe it will in Michigan with the advent of these new court rules. Because with 2.401J, we now have the ability to require parties to meet and confer about ESI issues specifically early in a case, often probably shortly after the pleading stage. These ESI conferences can be conducted by agreement of the parties, they can be conducted by order of the court, or they can be initiated by motion practice if one party anticipates that ESI issues are going to exist and the other party is not inclined to address them. At these ESI conferences, the parties are to consider Any issues relating to preservation of discoverable information, including adoption of a preservation plan for relevant ESI. Identification of potentially relevant types, categories, and timeframes of ESI. Identification of potentially relevant sources of ESI and whether the ESI is reasonably accessible. Disclosure of the manner in which ESI is maintained. Implementation of a preservation plan. The form in which each type of ESI will be produced. What metadata, if any, will be produced. The time to produce. The method for asserting or preserving claims of privilege. Privilege log formats, the method of asserting or preserving confidential and proprietary status of information produced, whether allocation of expense is appropriate, and any other issue related to the discovery of ESI. Within 14 days after this conference takes place, the parties are to file with the court an ESI discovery plan and a statement concerning any issues upon which the parties cannot agree. Unless the parties agree otherwise, the attorney for the plaintiff is the one who submits the plan to the court, and the ESI discovery plan can include a number of different things, a statement of the issues of the case, schedule of discovery, including a specific schedule for discovery of ESI, defined scope of preservation of information, the forms in which ESI will be produced, and the sources of ESI that are not reasonably accessible because of undue burden or cost. Now, when these conferences take place, there is an important requirement under the court rule, which is ESI competence. Attorneys who participate in an ESI conference or who appear at a conference addressing ESI issues must be sufficiently versed in matters relating to their client's technological systems to competently address ESI issues. And counsel may bring a client representative or an outside expert to assist in these discussions. So for attorneys who are less comfortable with ESI in general, this is going to be a potential issue going forward. If this is going to be an issue in a case and you don't feel comfortable that you have the technological knowledge to adequately address all of these requirements of the new rule, you're going to have to bring someone from your client's company, you're going to have to bring your client, or you're going to have to bring in an outside expert to assist. Because going to an ESI conference to hash out all of these issues without the ability to adequately do so is going to cause, not only is going to cause us as attorneys to lose credibility if we do it, it also may potentially open us up to sanctions if we are wasting the other side's time on an ESI conference when we're showing up without the ability to adequately participate. So this, again, is something that we're all going to have to be cognizant of going forward. This is something where if we're the party who anticipates that we're going to be asked for more information, I think we want to be using these ESI conferences. I think we want to use these to our advantages by trying to obtain some concessions at the very beginning of the case from the requesting party as to what we are going to be required to produce. At the same time, if we're the party who wants production of ESI, it's probably not a bad idea for us to be pushing for these conferences as well, because we want to know where we're going to see objections from the other side. We want to know what the basis is for the objections to producing ESI, and we want to find out as much as we can about the universe of ESI that they have accessible to them. So there are good reasons for attorneys on both sides to want to take advantage of this new rule and conduct these conferences. And again, these are conferences where not only can you have a client or a client representative with you, you can bring an expert with you that you've engaged to assist with ESI issues to the conference to help put together a protocol to make this happen. And Sean, why don't you tell us a little bit about what you've done in this regard?
Yeah, I like this change here, Ian, because it says that you don't have to be an expert in electronic discovery anymore, that you can actually bring someone to the table that has a little bit more knowledge about this. So I think this is great. Our clients routinely engage us to act as that expert and advocate on their behalf. And so the purpose of coming up with an ESI protocol, and we have a nice 15-page draft ESI protocol that we'll be sending to you in Word format that you can then use in your own cases. But we routinely see attorneys are frustrated with the way opposing counsel has produced data to them. We can all relate to that, right? And so, the ESI protocol gives us a roadmap to, during the course of the litigation, to go back and, this is what we agreed upon on how to exchange electronic discovery. These are the forms and formats we've agreed upon. So now we're putting everything out there in the forefront. Not that it can't be massaged later on, but at least it gives us a roadmap to how to deal with ESI issues going forward. One of the big parts of the ESI protocol is identifying metadata fields. And so we can work with you and your client to identify which metadata fields are going to be most helpful in your practice. But these are, some of the, metadata fields that we recommend using and putting in the protocol. And those will be part of the 15-page document that we provide. So for this, the last thing I want to say is that, you're not alone in this. I know it can be overwhelming. There is a lot of data out there. It's getting bigger and bigger. But the courts have said, you don't have to be an expert necessarily. And, our clients rely on us and lean on us. So hopefully, we can be a resource for you as well.
Thanks, Sean. As a quick recap, the things that we've covered today, we've talked about 4 different areas where the changes in court rules specifically address ESI concerns. We talked about preservation, we talked about initial disclosures, we talked about proportionality, and we talked about the availability of an ESI conference. We have had a question, which I think is a good one posed, which is concerns about the ESI that is in the possession of non-party witnesses. They don't have an obligation like parties do to preserve this evidence. What can we do to try to lock in this ESI so that it gets preserved and isn't lost? This is something that I think is I think it is an issue. The immediate things that would occur to me to address this would be, 1, getting subpoenas out as early as possible in a case. 2, potentially sending preservation letters to non-parties that we know are in possession of ESI. They don't have the same obligations that parties do, but if we are then following up later in the case with subpoenas and with motions to compel and things along those lines, I think we're going to have stronger arguments if we have warned these parties early on that they should be preserving the ESI. And I think another avenue to address this is through the new 2.401J. Rule 2.401J4 has a provision for an ESI order. It says the court may enter an order governing the discovery of ESI pursuant to the party's ESI discovery plan upon motion of a party by stipulation of the parties or on its own. So if we have concerns that there are third parties in possession of ESI that may engage in destruction or may not properly preserve that ESI, I think we could file a motion under 2.401J4 asking the court to enter an order in connection with the party's ESI plan that requires third parties to preserve the information that is in their possession.
Ian,
again, it's a new rule. It hasn't been tested, but I think that's a viable strategy. Go ahead, Sean.
Ian, just to kind of piggyback off that, and I would recommend getting specific in your request as well. We've seen, company A requesting all communication with company B, right? And so we suggest, narrowing down keywords, timelines, and those types of things to kind of narrow down even from non-party sources. So just get specific in your request is our recommendation as well.
All right, everyone. Well, thank you so much for joining this morning. We have ran out of time. However, we certainly want to be able to address any other questions that may arise. So please feel free to email us after this presentation any additional questions, and we will address those. And we will also be distributing a recording of this presentation along with a copy of the PowerPoint for your review. Thanks again for your participation, and we wish you all a great weekend.
Thanks, everyone.
Take care, everyone.
on the question.